120 words per minute. Ready? Start para. The learned advocate for the management has strenuously attempted to indicate that the management had no ill intention or oblique motives, since the management required teachers and imparting education was being hindered on account of the shortfall in the teachers. It has bona fide carried out the selection process. He further relies upon the roster and submits that there is no backlog and no fault can be found with the management. Paragraph. Having considered the submissions of the learned advocates and the learned AGP, and having taken into account all attending circumstances, we find that the petitioner cannot be faulted, neither laches nor oblique motives can be attributed to the petitioner. We find that the petitioner was responsible in any manner in or, or orchestrating his appointment. He responded to the advertisement dated 6th May 2014, keeping in view that he was already working in the same establishment oblique institutions as a part-time teacher from 1st September 2001. He was called for the interview on 22nd December 2014. He participated in the selection process in which 7 candidates had participated. He was found to be the best amongst all and was appointed on full-time basis, notwithstanding the fact that the management could not have done so, since it would amount to an illegality. Paragraph. The petitioner is right in contending that he is not at fault and he has no reason to have knowledge about the exchange of correspondence between the management and the education officer. Having participated in the interviews and having been assessed to be the best, he was appointed by the management. Paragraph. Considering the above, we do find that we could find any fault with the petitioner employee. Apparently, the sequence of events and the correspondence would indicate that the management has acted high-handedly. The Assistant Director of Education has brought it to our notice in the affidavit in reply that 94 teaching posts meant for the open category were duly filled in by the management, leaving no vacancy for the open category. Paragraph. In the above backdrop, we are required to apply our mind to a possible repercussion that would follow if this petition was to be dismissed on the ground that the management had illegally appointed the petitioner. The petitioner would lose his job after 10 years as a full-time assistant teacher, since we are informed on specific instructions taken by the learned advocate for the management and the learned AGP that the petitioner is working on day-to-day basis ever since his selection and appointment. This would unsettle the petitioner, who will be thrown out of employment. Having worked on part-time basis from 2001 to 1st January 2015, this employment is his only hope. At this age, he would be rendered to starvation and his family would be severely impacted. When he is in his early 50s at this age, he is not likely to get any employment. Paragraph. We find that the aforesaid situation is not irreversible, though the management needs to be penalized for the illegal act. If the petitioner has to continue in employment, we need to ensure that the backlog will have to be cleared by the management and no selections would be permitted without following the due procedure laid down in law and by clearing the backlog. Any post which would be available in future could be converted into a reserved category post and the backlog could be cleared. Full stop.